Welcome to the 14A District Court. I'm the Honorable Judge Simpson.
Can you guys hear that?
And I'm about to provide to you valuable information regarding this product and other matters. This is the Landlord-Tenant Summary Proceedings Act. You are here for a retrial. Your landlord has made allegations and findings that you should be evicted because you have not paid your rent or because they seek termination of your tenancy for a lease violation. After today, you will come back for an additional hearing or trial of the case unless you and your landlord reach some agreement. You have the right to have your case heard in proper venue. 14A District Court is located in Pittsfield Township, Washington County, State of Michigan. 14A District Court also holds jurisdiction over the following cities, villages, and townships. In essence, anything in Washington County outside of the city of Grand Arbor and Ypsilanti Township is covered in this court. You also have the right to demand a trial by jury. If you want a trial by jury, you must demand it orally at first appearance or in writing 5 days after first being advised of these rights and information. Jury fee must be paid when the demand is made or within 5 days after first being advised of these rights. Right to rental and other housing assistance. Within 5 days of first receiving these advice of rights and information, you must provide written proof to the court that an application for assistance has been submitted for process. Housing assistance and rental assistance may be obtained through the Department of Health and Human Services, commonly known as DHHS. They can be reached at their phone number of 1-877-696-6775 or through mibridges.dish.gov. Assistance may also be obtained by contacting Housing Access for Washington County, commonly known as HAWK. HAWK can be reached at their phone number, area code 724-961-1999. Additional assistance is also available through Washington County Veteran Services. Their phone number is 724-973-4540. Also, you may obtain housing assistance and other resources through coordinated entry resources. Their phone number is 745-6748. You do not need a judgment to obtain assistance from any of these agencies. The summons and complaint are sufficient. You have a right to reach an agreement outside of Michigan and local communities through resolution programs are approximately research. Washington County District Resolution Center can be reached at their phone number of area code 734-794-2125. Future rental lawsuits, your case may be resolved by additional dismissal and legal judgment if that is approved by all the parties and the court. It is important that you understand these things. If you have any questions, please feel free to address the court.
We have 675. All right. The 14th District Court of County of Washington, State of Michigan is now back in session. The Honorable Judge Simpson presides.
You may be seated.
Yeah. Sure.
Court does call the case of Arbor Manor versus Jamaica Jones.
Good afternoon, Your Honor. James Spink to the plaintiff.
Hello.
Hi,
What's your name?
Jamaica.
All right. What are we doing on this case?
Balance is 2803. Which is a little reduction from where she was,
Yeah.
20 something.
So my understanding is that there were some repair issues. Did those get taken care of, or where are we with those?
No, it never got to.
Looks like she was supposed to file a written answer by today.
She was supposed to file a written answer by today. She did submit her rental assistance form, so she would be entitled to another adjournment on this. But
Whatever you want to do, I don't have any information on the repairs, but I'll find out about them.
all right, because my understanding is from the last, right, if I'm wrong, but she had basically stated what some of the repairs were, what the repairs were, and counsel had indicated they were going to get to the landlord to try to talk about that.
Yeah, the note I have just says she has repair issues.
Okay. All right. Well, let's see if we can try to figure that out. November 21st, 2025 at 1 p.m. for you to come back. Ma'am, is there anything that you can pay either into escrow or to the landlord between that time and then and now?
I really honestly don't want to pay until they fix all my repairs because
I understand that. Okay. And that's why the option is also to pay into the court.
okay.
All right.
Yeah, I can pay into the court.
Okay. So how much can you pay?
1,100.
1,100?
1,100, yeah.
No, it's okay. It's okay. I got you. All right. So what I'll do is that you'll pay 1,100, but you'll pay that into court escrow. All right.
When will you do that?
Pardon?
When?
Yeah, when
Do
they're,
it today.
okay. It'll have to be cash so that you know.
Okay.
So, all right. I'll put that you'll do that by Monday. All right. In case you have to do whatever. Okay. The other thing, have you heard back from your SER at all or no?
They denied it.
Okay. Okay. So they gave you an answer on that. Have you contacted Hawk regarding payment of the other amount or anything?
No.
No? Okay. So you might want to reach out to them. There's some funding that is available in case you need it.
Okay.
Okay? All right.
All right. Thank you.
Thank you.
Your Honor, could we just reserve escrow just in case something
Yes.
goes wrong? I won't submit an order unless she didn't pay into the court.
Court. Okay. That's good. Okay.
Thank you.
All right. Thank you. Cherry Hill Administration versus Dion Ragley.
Chief Sink for the plaintiff.
Hello.
Hey, how you doing?
What's your name? Name? Dion Ragley. You?
Alila Horton from Washington County.
I thought so. How are you today?
Good.
All right.
How are you?
All right. Where are we on this case, Mr. Ragley's case?
I've got the balance at 9,900. They did give us a list of money orders and he's been credited for all but two of them. That total, like,
1,000.
uh,
Was it more than that? It was 500 and
it was the 675 and the 550, so 1,225.
1225.
So he thinks that he submitted 1,225 in money orders, one for 675 and one for 550 that we don't have.
Okay, so there's about 1,200. Okay.
I think he intends to move. Yeah.
Okay. Okay, so you're going to move?
Yes.
Okay. When do you plan on doing
Well, after I got all this information today, so in the next couple of weeks.
24.
24. So when you,
Yeah.
I, just listen,
Yeah. Oh,
but you got someplace you're going or,
yeah, I have somewhere to go until the meantime.
okay, so you got someplace to temporarily
Yeah, yeah.
stay. You're not going to just leave because you think you have to leave right now.
No,
Got to
no,
be
no,
out there.
Right,
Okay,
yeah.
that's what I want to make sure. Not going to happen.
no.
Okay, so you think you can be out by what date?
I just got all this information today. It's as far as
No, I
I
got
didn't need some time because I got to get storage, a truck, and move stuff out. So,
When you think you can be out? Today the 14th.
Let me ask you this. Today, can you be out before the end of the month? You think? Or are you going to need more time than that?
yeah, I'll probably need a little bit more time because of how I get paid and stuff. So,
All
and I
right.
got to have money.
Okay, so here's what I'm going to do. Because I normally would just give a judgment today, but the number is not going to. It's going to be what it is. So I'm going to adjourn you out, Mr. Ragland, and let you come back on the 21st, 2025 at 1 p.m. Okay? Here's what I want you to do. It's likely I'm going to issue a judgment at that time. Give you a time frame
Okay.
by which you need to move out.
Yes.
But I'm trying to give you time to get a plan in place for how you're going to do this.
Right.
You're not just trying to pile everything into a truck and just go.
Right. Yeah.
Okay. And I think that's what you don't want to do.
Right. Right. Yeah.
And so I'm going to give you that with this week to try to get that straight.
Okay.
We could just make it the
No,
28th. Oh, no, that's it. Well, that's a.
I put it into the next month. He may be there, but I want to. I hear you, Mr. Fink, but
I would have to come back if we can figure out the.
right. And if it can be work, no, I hear you, but I also don't want Mr. Ragland. I want him to have time to kind of
Yeah.
be able to make some decisions and
Right.
just try to work it out for himself in a lot of ways. He's got it. The first part figured out that he's got to move.
Right.
The next part is he's got to figure out how he's going to do that
Exactly.
and as comfortable as move can be, comfortably do it. So I'm going to do it that way. Okay.
Yeah. That's
Right?
fine.
But when you come back, I need you to have sort of things
Yeah. Oh,
in
yeah.
place as to how you're going to do this.
Yes. No. No.
Okay.
Yep.
All right.
All right.
Take care.
All right. Thank you. Appreciate
Thank
you.
you. Have a good one.
Forrest Knoll versus Shemaya Charles.
Jason for the plaintiff.
Charles, not here. You've previously been sworn. You may proceed.
I'm still sworn.
Yes.
Your Honor, this is an action for non-payment of rent. This defendant owes $666 in rent. The costs are $175 for a total possession only judgment of $841.
Judgment to the plaintiff. That's by default for possession. Redemption amount requested. With issue intent case. Forrest Knoll versus Rosalind Latt.
James Fink for the plaintiff.
Yeah, I get a,
Let me see if it's on.
I got a receipt if you want.
It should be on here. Let me look.
The 500.
I gave him 675 yesterday.
You paid more than what you said you were going to.
Yeah. Oh, I got the receipt in here, that's why.
No, it's okay.
My ledger is dated yesterday and it does not include that. So assuming that's correct, she would be, the balance today is $1,278. If she paid 600, she'll only need to pay another 678.
When do you think that can happen, ma'am?
I can Instacart and have it by Thursday, or I get paid.
You can have it by next Thursday?
Yeah.
Is Thursday coming up?
The Wednesday after next too, if, to be safe.
Well, if you get it paid by next, he's gonna adjourn it a week, and if you get it paid by next Thursday, I can do
They'll
it.
dismiss it.
Okay.
You do that?
Yeah.
You want to do that?
Yeah.
Okay. I'll adjourn it to November 21st, 2025 at 1 PM. Okay? Get it paid and hopefully we can just dismiss this.
Okay, thank you.
You take care.
One of my brother's best friends.
Really?
Yeah.
Peninsula Place Apartments versus Michael Pugh. Yes. Mr. Pugh?
Yes.
Okay, there he is.
James Fink for the plaintiff.
All right, what do you have as a... Well, you looked that up. Did you pay the 800 already?
Yes, I did.
Okay, when did you do that?
I did it, I would say probably 3 days ago.
Okay, so you paid it earlier than, okay. So they may hit in the balance.
I have 2170.
Given what, well, no, because November came around. The last time you were here was October 31st. Okay. So how are you intending on getting the rest of this paid off?
So I start my new job next week, and that was our main issue was like seeing how I would pay it until I started work. But I had paid the 800, and I start working next week.
Okay. Then you don't get paid for.
They have an option. It's like it's weekly pay, but they have an option after setup where I can get paid like after every shift.
Okay, I see what you're saying. All right, so here's what I'm going to do, sir. I'm going to find no tribal issue. I'm going to issue a judgment for possession in that full amount. And what I'm going to suggest that you do, I'll give you a little bit more time, and I'll give you till, it normally would be the 24th, but a writ will be November 26th, so I'll give a couple more days. You need to reach out to the landlord and the attorney's office, have a concrete plan, see if they can work with you to give you time to get this paid off. Okay?
Okay, and what time on the 26th? Or
Well, that's not a court date. That's a date that they can at least request the court to have you evicted. So that's
Okay.
why you got to call, you got to get to them, see if you can work it out based upon how your pay is. Because you're right, we're waiting on you to get yourself working. You paid the 80. That kind of kept you sort of steady coming into November. But now you got to get with them and get a plan as to how you're going to move forward.
okay,
All right?
all right.
Okay, I've signed that judgment. Thank you. River Drive Apartments versus Ann Marquette. Marquette, I should say.
James Fink for the plaintiff.
Don't know why I'm putting an extra syllable in it.
Your Honor, can we either approach or go off the record?
Yeah, correct.
Welcome to the 14th District Court. I'm the Honorable Judge Simpson, and I am about to provide you valuable information regarding this current and other landlord-tenant. Landlord-tenant or summary proceedings. You are here for a retrial. Your landlord has made allegations and claims that you should be evicted because you have not paid your rent because they seek termination of your tenancy for lease violation. After today, you will come back for an additional hearing or trial.
Okay.
In these proceedings, you have the right to have your case heard in the proper venue. 14A District Court is located in Pittsfield Township, Washington County, State of Michigan. 14A District Court also holds jurisdiction over the following cities, villages, and townships. In essence, anything in Washington County outside of the city of Ann Arbor and Ypsilanti Township is covered in this law. You also have the right to demand a trial measure. If you want a trial measure, you must demand it orally at first appearance or in writing 5 days after first being advised of these rights and information. Jury fee must be paid when the demand is made or within 5 days after first being advised of these rights. You have the right to rental and other housing assistance. Within 5 days of the first receiving these advice, rights, and information.
At the 14A District Court Landlord-Tenant session, the judge began by explaining eviction and rental dispute procedures, including tenants' rights to demand a trial, request a jury, and apply for housing or rental assistance through state and local programs. Several cases were then heard involving unpaid rent and lease violations, where tenants either owed balances, disputed charges, or were preparing to move out. In multiple matters, the court allowed payment plans, escrow payments, or short extensions of time instead of immediate eviction, while also warning that failure to comply could lead to possession judgments and writs of eviction. Overall, the proceedings focused on balancing landlords' financial claims with tenants' repair complaints, financial hardship, and need for additional time to resolve their housing situations.